Hi Ankita. Hi Ravi.
Hi Madhuri.
I think we should start now.
Yes.
Ravi, we start now the introduction of Ankita.
Good afternoon to all my respected seniors and all my professional colleagues. I would like to welcome all of you to this knowledgeable and interesting session. The topic for today's webinar is SS-3, that is Secretarial Standards on Dividend, and SS-4, that is Secretarial Standard on Report of Board of Directors. Before starting this session, I would like to give a brief introduction about today's topic. Firstly, on SS-3, that is Secretarial Standard on Dividend. Dividend is issued by the Institute of the Company Secretaries of India. It is more likely a reward to the shareholders for the investment made in the share capital of a company, and it has been inclusively defined in the Act so that it includes the effect of interim dividend also. Now, I want to give a brief introduction about SS-4, that is Secretarial Standard on Report of Board of Directors. Board of Directors report is a report prepared by the board of a company to and for various disclosures made in the directors report. SS-4 SS-4 prescribes a set of principles for making disclosures in the board's report of a company. Before reading forward, I would like to introduce Ms. Ankita Dutta ma'am, the key speaker of our today's webinar. CS Ankita Dutta is a commerce graduate from Jivaji University. She is an associate member of the Institute of Company Secretaries of India and partner at Mamta Binani and Associates. Her core areas of expertise and recent assignments handled includes corporate law consultancy, securities law practices, FSSAI registrations, MSME matters, trademark registration, NCLT matters, NBFC compliances, secretarial audit, due diligence, drafting legal agreements and contracts, etc. She has also written articles on company law matters, which got published on various recognized websites. She frequently appears before MSME Council, representing various MSME cases. Now, I would like to request CS Ankita ma'am to take forward this session. Over to you, ma'am.
Thank you so much, Ravi. Thank you for the introduction. First of all, I would like to ask, am I audible to everyone?
Yes.
Okay, thank you. Thank you for the confirmation, sir. Okay, so today's topic is Insights on Secretarial Standard on Dividend and Report of the Board of Directors. But before going forward with this topic, I would like to just give a brief why I have chosen this topic for today's webinar. As we all know that the July to September quarter has just begun and all the companies are required to hold their AGM in this quarter itself. And these two things, that is dividend declaration and report of the board of directors, are what it is important in the AGM. In the AGM, the companies will declare the dividend. The companies will declare the dividend and the board will prepare the board's report. So we thought it would be appropriate to discuss these both topics in this webinar. Okay, now starting, can I share the screen, Madhuri? You can. Thank you. Is my screen visible to everyone? Can everyone see the screen?
Yes, it is visible.
Okay, thank you. So before starting with the topic, let's understand that what was the need for secretarial standards. So basically, the Institute of Company Secretaries of India has issued till now 10 secretarial standards, out of which SS-1 on board's report, on board meetings, and SS-2 on general meetings are mandatory to follow. These two standards were issued in October 2017, and exactly after 3 months, SS-3, that is Secretarial Standard on Dividend, is issued in January 2018, and SS-3, SS-4 on report of the Board of Directors were issued on October 2018. And subsequently, guidance note on SS-4 was also issued in May 2019 by the Institute. Now, SS-1, following SS-1 and SS-2 are made mandatory by the Institute, while adherence to SS-3 and SS-4 are recommendatory. Okay, so to address the areas where law is silent, ambiguous, or some terms have multiple meanings, the secretarial standards were introduced. So basically, for a better understanding, better clarity, and for a good corporate governance practices among the corporates, the secretarial standards were introduced. Okay. Now moving on to the next slide. Before moving with what is dividend, I would like to just give a brief about the scope of SS-3. So basically, SS-3 covers the declaration and payment of dividend. It is applicable on equity and preference share capital. Dividend includes financial and interim dividend both. Okay. Now this SS-3 is not applicable on companies which are limited by guarantee and does not have share capital. Okay. And if any dividend is declared by companies which are under liquidation, then these standards are not applicable, not at all applicable. Now, what is dividend? Dividend is a return on investment made by the promoter or shareholder in the share capital of the company. So it means that it is not same as the return on borrowed capital, which is in the form of interest, and capitalization of profit in the form of bonus share is not dividend. Okay, so we can conclude that how dividend works. First, the company generates profits, then the management decides some excess profits which are to be distributed among the shareholders as dividend. Then the board approves the recommended dividend. Then the company announces the dividend, and then subsequently the dividend is paid to the shareholders. In common usage, dividend refers as the share of profit that is distributed among the members. Now, dividend cannot be declared without the recommendation of the board. Whether it is final dividend or interim dividend, the board must first recommend the amount of dividend. As I have already told, that dividend includes interim dividend also. Final dividend can be declared only at the AGM, and interim dividend can be declared at a board meeting, which means for declaration of interim dividend, approval of the members or approval of the shareholders are not at all required. Okay, now what are the applicable laws on dividend? We all know that Companies Act 2013 has already provided section 123 to 127, which is in chapter 8 of the Companies Act, which relates to declaration and payment of dividend. So yes, Companies Act is very much applicable on declaration and payment of dividend. Then for listed companies, SECRA and SEBI, LODR is applicable. And for income tax, and the income tax is also applicable while payment of dividends. Am I clear till now?
Yes, you're very much clear.
Thank you. Then moving on to the next slide, that is important definitions. I have taken some definitions which are important in respect to SS-3. First is, what is dividend? Dividend means distribution of any sums to members out of the profits and wherever permitted out of the free reserves. Now, what is final dividend? Final dividend means that dividend which is recommended by Board of Directors and declared by the member at AGM. Next is, what is interim dividend? Interim dividend is declared by the Board of Directors. Next is, what is free reserves? Free reserves means those reserves which, as per the latest audited balance sheet of the company, are available for distribution as dividend. Okay. Now, there are certain amount which are not considered or included in free reserves. Our next slide is all about that. So what is not included in free reserves? Any amount which is representing unrealized gains, notional gains, revaluation of assets are not included in free reserves. Let's understand what is unrealized gains. So I have taken an example. Suppose company A owns stock of worth rupees 10K, and then the value of the stock rises to 15K. Obviously, the company has gained a profit of rupees 5K, but it will not be considered as income for the company, and this will be referred as unrealized gain until and unless the company actually sells the stock and the cash is collected. Only after the cash is collected, these unrealized gain will be considered as realized gains. Next is notional gains. Notional gains are gains which you have not made unless it is actually earned or reflected. Let me take an example first here. Suppose I own a plot of land and the value of that land increases. Now the gain is notional here unless I actually sold that plot of land. Next is what is revaluation of assets. If revaluation is opted for so as to reflect the change in the market value of the assets. So revaluation, we all know this is nothing, but this is a change in the market value of the assets. Now, there is other thing also which is not included in reserves, that is any change in carrying amount of an asset or liability recognized in equity, including surplus in P&L account on measurement of the asset or liability at fair value. So friends, carrying amount is nothing, but it is the book value of an asset or liability. Moving on to our next slide, let's discuss what are the sources of dividend. We all know that basically there are three sources. First is from current year's profit, a company can declare dividend. Then out of profits for any previous financial year, which remains undistributed after providing for depreciation. Now there is a catch here that dividend shall not be declared unless carried over previous losses and the depreciation which are not provided in the previous year are set off against the current year profit. Let me give an example here. Suppose a company has earned a profit of rupees, say 1,000 rupees in current year, and the accumulated losses of previous year is rupees 100. And suppose a depreciation which are not provided in the previous year is rupees 200. Okay. So now the company will be only able to use rupees 700 for declaration of dividend, although the company may transfer any amount of profit to the reserves for declaring the dividend. Okay. Now, the third source from which the companies can declare dividend is out of the money provided by central government or state government in pursuance of a guarantee given by such government. So basically, these are the three sources from which the company can declare dividend. Although we have to keep in mind that before declaration of dividend, all the carried over previous losses and the depreciation which are not provided in the previous year must be set off with the current year's profit. Now, the next slide is sources from where dividend is not to be declared. So basically, the Act or SS-3 has provided certain sources from where the dividend is not to be declared. The first one is from securities premium reserve, the dividend shall not be declared. From capital redemption reserve, the dividend shall not be declared. Revaluation reserves, amalgamation reserves, out of profits on reissue of forfeited shares, and if there are any profits which are earned prior to incorporation of a company, then those profits shall not be used for declaring the dividends. Now, we have talked about the sources from where the dividend can be declared and the sources from where dividend cannot be declared. But let's understand that when a company cannot declare dividend, there are certain circumstances when the dividend cannot be declared by a company, or only if these circumstances or these defaults are made good, then only then a company can declare dividend. So a company cannot declare dividend if it has non-complied with the provisions related to acceptance of deposits. So if there is any non-compliance related to acceptance of deposits, and until that default is, or until that compliance are made good by repaying the deposit amount along with interest, the company cannot declare dividend at all. Next, if a company has defaulted in redemption of debentures or payment of interest or creation of debenture redemption reserves, then the company cannot declare dividend. If a company has defaulted in redemption of preference shares or creation of capital redemption reserves, then also the company cannot declare dividend. If defaulted in payment of dividend declared in current year or previous years. Next is, if there is any default in repayment of term loan or interest to any bank or financial institutions, then also the dividend cannot be declared by any company. So basically, to declare the dividend, the defaults must be made good. If there are any defaults, that the company shall make sure that those defaults are made good, and then only you can declare the dividend. Now, can dividend be declared out of free reserves? So yes, only final dividend shall be declared out of free reserves if profits are inadequate or there are no profits. However, there are certain conditions. After complying with these conditions, the final dividend can be declared. So you may ask here that whether interim dividend can be declared out of free reserves. No, not at all. Even if the company has inadequate profits or there are no profits, interim dividend cannot be declared out of free reserves. Interim dividend can only be declared out of surplus in the P&L account and current year's profit. Now let's see what are the conditions that are to be complied for declaration of dividend out of free reserves. The first condition is rate of dividend declared shall not exceed average of the rates at which the dividend was declared in the 3 financial years immediately preceding the financial year of declaration of dividend. Second is the total amount to be drawn from the accumulated losses shall not exceed 1/10 of the paid-up share capital and free reserves as per the latest audited financial statements. Next, the balance in reserves after drawing such amount shall not fall below 15% of the paid-up share capital as per the latest audited financial statements. The next condition is the amount so drawn shall be first utilized to set off the losses incurred in the financial year in which dividend is proposed to be declared. So after complying with these situations, the companies can declare final dividend out of the free reserves. Now there are certain milestones, certain timelines which are provided for declaration of dividend, and these timelines are very much important. We have to keep in mind these timelines, and we should advise accordingly to our clients these milestones, because if we don't comply with this timelines, it may cause, or it may result in imposition of penalties and fines by the government. So what is the timeline? What is the first timeline? The first timeline is the company shall deposit dividend in a separate bank account. Before declaring the dividend, the company shall open a separate bank account and it should deposit that amount within 5 days from the date of declaration. Then within 30 days from the date of declaration, the company shall pay the dividends. Suppose the company is unable to pay the dividends due to the reason that there is some unpaid or unclaimed dividend, those dividends which are not claimed by the concerned members. So if there are such unpaid or unclaimed dividends after 30 days from the date of its declaration, then such unpaid dividend must be unpaid dividend or unclaimed dividend must be transferred to a scheduled bank in a special bank account, which is to be named as unpaid dividend account within 7 days from the expiry of 30 days period from the date of declaration of dividend. Now suppose if the unpaid or unclaimed amount is still lying in unpaid dividend account for a period of 7 consecutive years from the date of transfer to such account. No one has claimed, if no shareholder has claimed such amount and it is lying in that particular account which is opened by the company for 7 consecutive years. So this means if any amount is paid or claimed during this 7 consecutive years, those amounts shall not be transferred to this fund, which is known as the Investor Education and Protection Fund. If only the unpaid or unclaimed amount is lying in that fund, in that account for 7 consecutive years, then only along with interest and that particular amount will be transferred to IAPF fund. What is the timeline? The timeline is within 30 days from the expiry of 7 years from the date of transfer or unpaid or unclaimed dividend to such account. Now, there are certain things that the company must do before transferring the amount of dividend to such fund. First is the company shall make sure that they have to send individual notices to every concerned shareholders regarding that their dividend is unclaimed or unpaid, and this notice shall be sent within approximately 3 months. Exactly, actually, it must be sent exactly 3 months in advance. At least 3 months in advance, you have to send that notice. And the company has also shall make a newspaper advertisement, which should be in one English newspaper and one regional language newspaper where the company's registered office is situated. Now, in the SS-3, there are certain key takeaways which I have written here in a summarized manner. The first is distribution of discount coupons to all the shareholders shall not be treated as deemed dividend. Next, a company is prohibited to issue bonus shares in lieu of dividend. This particular thing we all know. We have read this in numerous times in Companies Act. Next is dividend to be paid only to the registered holder of shares or their order or to their bankers. Now you cannot pay dividend to any person claiming he is related to the registered holder. The dividend must be paid to the registered owner of the shareholder. Next is preference shareholders shall be paid before preference shareholders shall be paid dividend before equity shareholders. I think that is why the preference shareholders are called preference. The word preference is put before their name because yes, we have to pay dividend to preference shareholders before equity shareholders. But in case of interim dividend, preference shareholders shall not need be necessarily be paid before equity shareholders, which means if you are paying interim dividend, then the preference shareholders, it is not necessary that you have to consider paying dividend to the preference shareholder first in case of interim dividend. Okay. Next is dividend in Indians shall be transferred to the unpaid dividend account. Now suppose if the amount of dividend in respect of certain shares for which instrument of transfer has been delivered, but due to some valid reason that particular instrument is not registered, in that case the dividend must be transferred to unpaid dividend account. Next, let's talk about taxes. That there are TDS which shall be deducted by the company on the account of dividend as per the prescribed limit of the Income Tax Act. Now, next is dividend shall be paid in cash and not in kind. So yes, dividend shall be paid in cash and it should not be in kind. Next is dividend checks or warrants. The validity of dividend check or warrants are 3 months from the date of issue. The particulars of fresh dividend checks or warrants shall be registered, shall be put in the register of dividend warrants which is maintained by the company. Okay. Next is issue of duplicate dividend check or warrants only after obtaining indemnity or declaration from consent members and after ascertaining encashment status of the original dividend check or warrant. So, in case the concerned shareholder requests for a duplicate dividend check or warrants, the company has to make sure that proper disclosures are taken from that concerned members, and the particulars of duplicate dividend check or warrants are put in the register of duplicate dividend check or warrants maintained by the company, so that it will be easier for the company to just look in the future that to which shareholders this duplicate dividend checks or warrants are issued. Next is, okay, now I would like to discuss here about the contents of the dividend check or warrants. What are the things that is written in the dividend check or warrants? Obviously, the name of the shareholders are written, then the number of shares, the amount of shares, then the folio number, check, then client ID, DP ID. These are the things, these are the basic things which are written in the dividend warrants or checks. The dividend once declared cannot be revoked. Yes, because now it's a debt. It's a debt for the company. The company has to pay the dividend. It is under the obligation to pay the dividend. Now, preservation of dividend check, warrants, and dividend register for a period of 8 years. Now, the company has to mandatorily preserve the dividend check and warrants for a period of 8 years, and only after taking proper approval from the board, the company can destroy that dividend check, warrants, or dividend registers. Now, next is whether we have to make any disclosure in the board's report about the dividend amount. Yes, disclosure related to amount paid for interim dividend and final dividend recommended by the board shall be disclosed in the board's report. So we have seen that dividend is an important thing. It is a reward. Yes, it is actually a reward to the shareholders. It is
continue
to the shareholders. So yes, dividend must be paid to the shareholders, keeping in mind the laws prescribed under the Companies Act and SS-3. Next, let's move on to board's report. What is a board report or director's report? It is basically a means of communication by the board of directors with its stakeholders. It should provide both financial and non-financial information. It includes performance and prospects of the company, any relevant changes in the management or capital structure, or recommendation as to distribution of profits, future and ongoing programs or expansion, further issue of capital, and various things are included in the board's report. Okay. Now, one thing is there that the board's report we should avoid while drafting. Being a company secretary, what I should keep in mind while drafting a board report. I think the first thing which I should keep in mind is that it should avoid repetition of words. It doesn't look good when you write a single sentence or word in numerous times. So we should avoid repetition of words in board's report. And if any information is there in financial statements which we can actually use in our board's report, we should give reference to that financial statement or particular note which is mentioned in the financial statement. We should not just directly copy and paste. Next is the board report shall be based on standalone financial statement and not on consolidated financial statement. Who can sign the board's report? If the board has authorized the chairperson, then that chairperson shall sign the board report. And if the chairperson is not authorized, then at least by 2 directors, one of whom shall be MD. And for OPCs, obviously, if in OPCs have only 1 director, then that 1 director should sign the board's report. Now, what are the laws that are covering the board's report? Obviously, Companies Act, Section 134 is covering the board's report in Companies Act. There are, for listed companies, SEBI has introduced SEBI LODR. Then secretarial standards and guidance notes are there. Though that does not, as I have already told, that secretarial standards are not mandatory. SS-4 is not mandatory to follow. But we recommend that SS-4 must be followed by drafting the board reports. What are the other laws that are applicable? Suppose my company is doing insurance business, then IRDA and POSH. POSH is related to prevention of sexual harassment in the workplace. These acts or these laws must be kept in mind while drafting board's report. Now, what are the disclosures that we have to give in board's report? First of all, the board report shall contain company specific information. What is company specific information? Company specific information is the board report shall contain the financial summary and highlights of the financial statements, like if there is any amount which is to be transferred in the reserves, if there is any dividend which is to be declared, if there is any unpaid or unclaimed dividend which is transferred to the IFPF fund, what are the amount it is transferred or that is declared or that is paid to the shareholders as dividend. Then if there are certain major events that has occurred in the company, suppose I am carrying a business of clothing in the line of clothing, and in a financial year I have decided let's do some other business, let's start one more business, or let's start some cement business. So I must include in the board report any change in the nature of business. Then the state of affairs of the company shall be mentioned in the board's report. Then if there is any financial statement or commitment which is affecting my financial position, I must include that also in my board's report. Now I have seen in certain cases that there are revision of financial statement as per section 133 of the Companies Act. So if there is any revision in the financial statement as per the order of the court or tribunal, I must include that the details of revision which are being made in the financial statement in my board's report. Now there are certain general informations also which are to be included. Those are the industry overview. What the kind of industry, what business I am carrying, and what my competitors or other or other companies with the same line of business are carrying. I must include that in my in the overview, in the industry overview section of my board's report. Then I must include economic outlook, external environments. Then if suppose I am a listed entity and I have applied for delisting, if I have applied for delisting activity, then I must give the details of delisting activity in my board's report. Next is capital and debt structure. Now, suppose if there is any increase in the authorized share capital, I must include that in my board's report. Now, if there is any, say, details or related to sweat equity issue or issue of ESOP, or if there is any reduction in my share capital, so I must give all the details related to my share capital debt structure in the board's report. Now, IFPF fund. I have already told that we have to include the information of dividend in board's report. So yes, if we have any amount which is transferred in IAPF fund, we have to include that also in our board's report. Next is management information. What is management information? Management information, we have to include the details about the directors, KMPs, independent directors, whether declaration from independent directors are taken or not, whether for listed companies, we all know that we have to nowadays we have to do the performance evaluation. So we have to give the details of the performance evaluation in our board's report. And then what are the things? Then yes, if we have a CS, we have to include the details of the company secretaries in our board's report. Then comes subsidiary, associate, and joint ventures. Suppose a company is having any subsidiary, then we must include the details of the subsidiary, the performance, or their financial position. We have to give entire details of our subsidiaries, associates, and joint ventures. And by the details, I doesn't mean only the name. We should also include about the performance in our board's report. Next is deposit. Yes, if we have taken any deposits, if the company has taken any deposits, then we have to include such details in the board's report. Next is loans, guarantee, and investments. The particulars of loan, guarantee, and investments are also to be included in the board's report. Suppose a company has taken loan, guarantee, or investment as per section 186 of the Companies Act, then it must give such details in the board's report. Then what next? Next is RPT. As per section 188, if we have done any RPT transactions, then we must give the disclosure in the board's report. Next is annual report on CSR. We all know that certain companies which are mandatory, for which CSR is mandatory, they have to draw an annual report on CSR, and they have to give entire details that how much amount they are investing, how much amount is not invested or not spent. We have to give entire detail in this. Along with that, we have to give the whether the CSR policy, about the details of the CSR policy and CSR committee are also to be included in the board's report. Next is what are the policies that are taken for risk management. We also have to include that. And if you have any visual mechanism or whistleblower policy, then also you have to include that in the board's report. And for visual mechanism, the companies which are maintaining their website, they also have to give the details in the website of that company. Now, who are my statutory auditors? And if there are any qualified reports or any observation we got from the statutory auditor, we have to include that information also in our board's report. Now, if there are certain frauds which are reported by the auditor, we have to also mention those things in our board's report. Now, secretarial audit report. We have to include the secretarial. It should be made a part of the board's report. The entire secretarial audit report should be made part of the board's report. Now, if there are the disclosures related to POSH, suppose the company, we have to include the details of internal complaint committee that is maintained by the company, which will also include the internal complaints that has been received, or if the resolutions which have been provided, we have to include the details. Only the numbers are to be given in the board's report, not the entire details about what were the complaints that have been received. Only you have to mention the numbers, that how many complaints are received and how many are resolved and how many are pending. Okay, next is compliance with secretarial standards. Yes, whether the company is complying with the SS-1 and SS-2, you have to give the details in the board's report. Now, next is corporate actions. So what are the corporate actions? Suppose a company is under CIRP. So you have to give the details that whether any application, which application is filed under CIRP, whether the financial creditor or OC or FC has filed an application. You have what is the situation, or what is the correct situation in the of the company in before the court or tribunal. You have to include such information in the board's report. Next is, suppose my company is in merger, so you have to give the details of that particular merger and what are the orders, what is the status of that particular merger before the tribunal. You have to give all such details in the board's report. Apart from these all, there are certain requirements which are to be complied with, which are to be complied under LODR by the listed entities. Suppose there are statement of deviation or variation. Those statements are to be included in the board's report. MDAR is Management Disclosure and Analysis Report. This Management Disclosure and Analysis Report includes the opportunities and threats, industry outlook, then industry overview also it includes. Then it includes the risks which are there in income. Then you have to give segment-wise reporting in your Management and Disclosure Analysis Report. Next is Certificate on Corporate Governance. Yes, a certificate on corporate governance is to be taken from the statutory auditor or from a practicing company secretary. Only 2% can give the certificate on corporate governance, statutory auditor or a practicing company secretary. Next is BRR or BRSR. What is BRR? BRR is Business Responsibility Report. Or from financial year 22-23, all the listed companies, all the listed, not all the top 1000 listed companies are required to give a business responsibility and sustainability report. Okay. Next is suspension of trading. Suppose the company has applied for suspension of trading, then such details are also to be included in the board. Now there is a timeline a timeline within which the listed companies have to submit their financial statement along with the board report to stock exchange. That is within 21 working days of its being approved and adopted in the AGM. Friends, the listed company shall send the their financial statement along with the auditor report and board's report to every member of that particular listed company. Next, I have prepared some FAQs which I thought would be appropriate to discuss today. Let's start with the FAQs. Can a Section 8 company declare dividend? No, a Section 8 company cannot declare dividend as the Section 8 companies are prohibited to declare dividend to its members. Can members increase the amount or rate of dividend recommended by the board? No, members can declare dividend at a lower rate than recommended by the board, but it does not has the power to increase the amount or rate of dividend recommended by the board. Next is whether areas of dividend on equity shares is allowed post adoption of accounts in AGM. No, no dividend shall be declared on equity shares for previous year in respect of which annual financial statements have already been adopted at the AGM. However, the catch is here. However, areas of dividend on cumulative preference shares for previous years may be declared and paid. Next, is approval of board's report by circular resolution possible? Not at all, because in the act itself it is written that the meeting of the board of directors shall be conducted for approving the board's report. So section 179(3)(g) specifically provides that the approval of financial statement and board's report shall be considered in the meeting of the board. In addition to this, SS-4 also provides approval of board's report by means of a resolution passed at a duly convened meeting of the board. Next is approval of board's report by VC possible? We all know, yes. Now the MCA has provided this relaxation, the ministry has provided the relaxation that all the 5 items, that is approval on prospectus, approval of the board's report, amalgamation, mergers, demergers, takeover, acquisitions, all these items, all the 5 items you can pass by VC. Next is, do we need to file board resolution approving the board's report with ROC? Yes, I have personally seen that due to non-filing of a single form, MGT 14, the companies have faced rejection letters from the ROC-RD office for certain corporate actions, like for conversion of a public company into private company. I have seen that the companies have not filed MGT 14, and due to this reason, they have to, got rejection letters. They completely stayed away that they got rejection letters. No opportunity of heard has been provided to them. So yes, you have to file the board resolution approving the board's report with ROC, as section 117G of the Act provides that resolutions passed in pursuance of subsection 3 of section 179 shall be filed with the ROC within 30 days of the passing of such resolution. Hence, MGT 14 is required to be filed by all public companies, whether listed or unlisted. Obviously, private companies are not required to be filed this because they has been provided with a relaxation by notification dated 5th June 2015. Okay. So yes, I think I have covered, I tried to cover the important aspects. If you have any queries, you can ask.
Yes, we have received certain queries in the chat box. So
Just let me see once. Can you please read, Madhuri, can you please read
yes,
the queries?
the first question was, in small companies, can dividend be distributed from company's account itself instead of opening a new account, since the number of shareholders will be very few?
Sir, Mr. Ravi Shankar, sir. Sir, thank you for the question. Sir, first of all, see in the Act or in SS-3, they have specifically written that you have to, open a separate bank account. So, as per my understanding, you have to open a separate bank account, whether you have a small company or not. You must open a separate bank account for declaring the dividend. It would be, it would be beneficial, also beneficial, if you keep in mind this purpose, that it will be easy for the company as well as for the ROC to, detect that this amount has been deducted from a particular account. A particular account has been maintained for this purpose. I think I am clear here.
Yes, yes, I too agree with you. Our next.
आवाज चली जाएगी दाढ़ी बनाना छोड़ दिया थक गए
I think Mr. Abhishek wants to ask something. Mr. Abhishek Srivastava? Oh no, he is just muted. Okay, next question.
Yes, our next question was with regard to producer companies. Are producer companies exempted from filing MGT 14?
In the Act, it is specifically written that only private companies are exempted. Then only private companies are exempted. You have, whether it is producer company, you have to file MGT 14. Only private companies are given the exemption. Private है तो बच गए, तो नहीं करना है.
Yes, do we have any other query? Okay. Our third query is, kindly throw some light on visual mechanism.
Okay, so visual mechanism is basically like, what to say? You can conclude it like that. Suppose if I am an employee in a company and I know that something is not going right in that particular company, and I take the initiative to inform the concerned person who I believe is not involved in that particular fraud or forgery. So it is like I am blowing the whistle against them. I am blowing the whistle that, see, this is something happening. This is something not right is happening in the company. Okay, and yes, there are policies. The listed companies, it is mandatory for the listed companies to have policies on visual blower mechanism, so that there are certain code of conducts which are some do's and don'ts are there. You have to follow each and everything. Madhuri, you are on.
Yes. Our next query is, what is the significance of circular resolutions now, since VC meetings are permitted for all matters except, just a second, except saving the sitting fee?
Okay.
Actually, I did not get the last part, so sir.
No problem. I have read it. What is the significance of the circular resolutions now, since VC meetings are permitted for all matters except saving the sitting fees?
Sitting fee.
Okay.
Yes.
So basically, sir, see, circular resolutions are, yes, you are right that since VC matters are now permitted by the MCA, why circular resolutions are required. See, there are certain times when a company cannot, convene the meeting immediately. There are certain matters that are very urgent for the company to discuss. So I believe for those matters, it is significant that circular resolutions are there. There are times when the directors are not immediately available for the VC meetings. So yes, I think it is important. It is important that VC meetings are there in our act.
Right.
No,
Our next query is
Madam, my query was that I'm Ravi Shankar. So I raised
Yes.
that sitting
Hi,
is
sir.
query. This is preparing a circulation, circulating, getting from signature from everybody will definitely take at least 3-4 days. Instead of that, you can hold a VC meeting in 2 days. One short notice, you can hold the meeting. That was my query.
So, but
So in fact,
then, sir.
VC meeting is a shorter thing than a circulation.
Correct. Now, sir, one thing I would like to tell here that for conducting the board meeting in a shorter period, you need to also take the consent. You need to take the consent in writing.
Consent in writing, we are recording in the board meeting only. That in directors, independent directors consent. We are taking the board meeting.
So if you are obtaining the consent from the directors, that will also take time. You will obtain it.
But we can record it in the minutes only, saying that the independent action. In fact, that can be taken post. That means I think after the next meeting also they can give consent. No, and before this meeting.
No, sir, you have to take it prior. On prior basis, priority basis, you have to take it. Otherwise, what is the significance of taking such consent?
Okay, so consent is an issue. Right.
I think, sir, I am clear here.
Right, I got it.
Thank you so much. Yes. Any other questions?
Yes, our next question is, in case of holding AGM through video conferencing, what if we have less than 50% emails of shareholders? Please suggest what we can do.
Sir, I would, who have asked this question? I think Mr. Narayan ji has asked this question.
CS Nayan.
Okay. So can I didn't got your ma'am, I didn't got your question. I mean, what
actually
may I?
Yes.
Yeah, actually we are unlisted public company and we are having more than 12,000 of shareholders, and as those are farmers, we generally do not have email ID to send the AGM notices and other documents to them. So is there any other way, or no, can we have any can say, what if I'm really having very less than 50% of the emails? So what record shall I keep? No, we have circulated it because it's a general thing that we publish it in newspaper. But besides that, we have to circulate the notice through email, right? So I have.
Yes, tell me. Complete your line.
So we have in the last 2 years was okay that the COVID was there, so we have no option. So this year, what we have to do? We have to email all the notices as far as we are having email, and others, do we have to courier them?
Yes, I was saying this point only. If you have email IDs, then you dispatch it on email IDs. If you do not have the addresses, you try to find the addresses. You show that you have made an effort, that the company has made the effort for obtaining the addresses of the shareholders. At least the effort should be there.
Okay.
It might be the fact that you do not get the addresses. It can be the case, but at least the efforts must be shown.
Okay. So it's okay if we don't courier the notices. We just have to mail them, right? What do you think?
Ma'am, I think you have to mail it. You have to mail it. You have to email the notices to the shareholders as well. You have to send the shareholders for which you do not have the email IDs. You must dispatch it by courier, or I mean speed post.
Yeah. Thank you so much.
Thank you. Yes, Mr. Karthik, we will share the PPT with you.
Everyone.
Don't worry. Yes, we will share it. Any other questions? If my audience have any other questions, they may ask.
Ma'am, I want to thank you because it was really a short and to the point and really informative session. Thank you so much.
Thank you so much, ma'am. I think no questions are
I
there.
also have a query with you, Ankita.
Yeah.
It is a
Yes.
very short and concise to the point.
Yes.
For example, means I want to ask that what would be the fate or what would be the right of the dividend in case the shares are held in events? For example, if the transfer is not yet done or it is not yet been registered by the company, or if the company has issued any bonus shares and it has yet not credited to the company, to the shareholders DPID account. So what would be the fate of the dividend? Means
Two
who
things
will
are there.
enjoy the right of it?
Yes, two things are there. First of all, the company shall have a valid reason. There should be a valid reason that why it is not registered. Okay. And in case it is not registered, then there is one option that is provided that you transfer that amount in a separate bank account, which is maintained with a scheduled bank, and that account would be known as unpaid dividend account. Okay.
Thank you. Do we have any other queries from anyone?
I think Sriram sir has.
Sriram sir, do you have any query?
You have done well. You have answered every questions very well. And
Thank
one
you.
question which made by Ms. Naina Thakkar. So you should update the address of everybody, ma'am. So you can make a public announcement in newspaper, and there is minimum more than 35 members is enough if you are having more than 5,000 members. So quorum is 35 and above is enough. So nothing to worry about your non-compliance in that part. Okay.
Okay, sir, just a minute. I just wanted to ask you that you had just told me that I should make a public notice for updating their addresses,
They can
right?
public announcement in newspaper. Ask them to provide who
Okay.
are the members of your producer company. Just give a public announcement in newspaper. Say that we are in the process of updating the members' details as per the latest updated details, so that they can provide the latest address to your company. So it is the only process you can do.
Sriram, it is the effort. That is what I was telling. That this is the effort which you have to make.
Okay, okay, okay.
Yes.
So
Okay, I think if there are no questions, we can conclude.
Yes, because we are getting ahead of time. So I would request Ravi to give you a warm vote of thanks, and then we can conclude and end this meeting.
I would like to express my gratitude. I would like to express my gratitude to all of you for your attendance in this webinar. Also, I would like to thank CS Ankita ma'am for enlightening us regarding the topic SS-3 and SS-4. Indeed, considering that the AGM, the companies are going to hold AGM in this quarter, it was really a very knowledge-enriching session, ma'am. Looking forward from such sessions in your near future. Thank you to all of you.
Thank you so much, Ravi. Thank you everyone for attending.
Thank you so much.
Thank you.